Hi guys, in the previous video we have studied section 7 and also the definition of promoter. So in this video we are going to start with section 8. It is section 8. Section 8 is about formation of companies with charitable objects. With charitable objects. What does subsection 1 says? That charitable objects means these are nothing but not for profit organizations. Section 1 says that you should provide documents to central government. Who should provide? Persons or association of persons. Who should provide? Persons or association of persons. Regarding what documents they should provide? Regarding what? They should provide documents to the central government. But what documents? Nothing but the object. The object for which you are going to start your section 8 company. What can be the objects? It can be related to arts, sports, social welfare, any charity. Arts can be related to commerce, sports, science, welfare for research, charity, religious purpose, or any other object. Next, what you should do with the profit? Whatever the profit generated during the business, what you can do? Where you can apply this profit? You can only apply to promote the object. These profits are only used to promote these objects. You cannot use this profit for any other purpose. Dividend. It prohibits. You cannot distribute the dividend. It prohibits the payment to its members. You cannot pay the profit in the form of dividend to its members. Central government. Can you easily start your section 8 company? No, you should have to get the license. Who will provide you the license? Central government. It may issue the license plus any condition as it may deem fit. The central government can issue the license along with some conditions that I am issuing you this license. You should only use this license for this purpose. It gives you some conditions and you should have to follow those conditions. What it allows? It allows. To whom it allows? To person or association of person to register with ROC. This license is used by the persons or association of persons who are gonna start section 8 company to register with the ROC. It is a limited company. You cannot use the word, cannot use words like private limited or limited. A section 8 company cannot use private limited or limited. When do you use this name? After end of the name of company. After the name, you cannot use private limited or limited to the end of its name. This is the subsection 1. Going with subsection 2, it can enjoy all the privileges and obligations of a limited company. What all the rights have, all the rights that are enjoyed by a limited company, the same is applicable to section 8 companies also. Third subsection, it does not allow a firm to be its member. So a firm can't be a member of section 8 company. You cannot allow a firm to be its member. Subsection 4, clause 1, section 8 company cannot alter its MOA and AOA. They cannot directly alter its MOA and AOA except with approval of central government. Once you get the approval of central government, you can alter your MOA and AOA. Without the permission, you cannot alter. The second clause says that section 8 company cannot be converted. Section 8 company can be converted by applying all the conditions. Once you meet all the conditions, you can convert your company into a limited or into a private limited company. It is allowed. A section 8 company can be converted to private limited or public limited by applying all the conditions, or by satisfying all the conditions you can convert your company. Subsection 5, any limited company incorporated under this act. Any limited company which is incorporated in this act can be converted into section 8 company. How it can convert? It can convert by fulfilling all the conditions. It can convert into section 8 company, and central government will issue the license to that company. What does it mean? So a section 8 company can be converted into limited company or private limited company. Just like that, a limited company can also be converted into section 8 companies. 6. Central government have the right to revoke the license of section 8 company. Central government has the right to revoke the license of section 8 company. When it can revoke? When there is any requirement in the law or in this section, any requirement by the law or in this section. If there is any requirement to revoke the license of the company, then central government will revoke the license, or it's an old condition, or any condition subject to which the license was granted, like any condition issued by the central government was not fulfilled, then central government can revoke the license. Any condition subject to which license was granted. If the condition is not satisfied, it can revoke the license. Like we have studied in subsection 1, while issuing the license, central government can also apply some conditions. If those conditions are not fulfilled, if those conditions are not satisfied, then central government can revoke the license. Or affairs of the company are conducted. When the affairs of the company are conducted, how they conduct? Why do you think if the affairs of the company conducted, central government can revoke? If the affairs of the company are conducted fraudulently, if the affairs are fraudulent or in a manner violent to objects of company. Suppose your objective of the company was education, but what you did is you started making profit by providing the education. It went commercial. Then of course the affairs of the company are conducted in a manner which is violent to the object of the company. Next, if it is prejudicial to public interest. In these three cases, central government has the right to revoke the license of the company. Does it directly revoke the license? No. In these cases, central government directs the company to convert its status. What does that mean? It will change its name. It will add limited or private limited in its name. So after adding this company will not be a section 8 company anymore. Registrar. What is the role of registrar in this? After that, registrar will register the name. It will register the new name and remove the name of the company from section 8 list. Before doing all this, opportunity of being heard is given. Suppose when you are given the opportunity, then the company has given a hearing that they are not wrong. So in that case, central government will not revoke the license. So this opportunity is given to the company, the section 8 company, so that they can prove themselves. Suppose if after even giving the opportunity of being heard, they were unable to prove themselves, then the license is cancelled and they are removed from the list of section 8 companies, and that order, central government will pass that order. That order shall be, the copy of that order shall be given to the registrar. The copy of order shall be given to the registrar. Registrar is nothing but ROC. Subsection 7 says that apart from changing its name from to private limited or limited, central government can order for winding up of the company or amalgamate with another section 8 companies in public interest. For the public interest, it can also order to wind up the company or amalgamate it with section 8 company. At the same time, opportunity of being heard is given to the company. Subsection 8 says, if amalgamated with another section 8 company which is having similar objective. If you are amalgamating with the same section 8 company that is having the similar objective of yours, then central government can order you. What it can order? To change. What is the thing that you can change? What is the thing that the central government order you to change? Change the constitution, the properties, the rights, the powers, interest, privilege, liabilities, duties and obligation. When you are going to amalgamate with same section 8 company having similar objective of yours, then central government has the right to pass the order to change the constitution, the property, the rights, power, interest, privilege, liabilities, duties and obligations of the company. Subsection 9. Suppose the central government has passed the order of winding up. You are winding up your section 8 company. So of course at the time of wind up there will be surplus left. There will be some surplus left. What do you do with this surplus? Either you transfer to another section 8 company with similar object, or it is credited to IBF, nothing but insolvency bankruptcy fund. Whatever the surplus left at the time of wind up, it is transferred to another section 8 company which is having similar objective, or it is credited to insolvency bankruptcy fund. Subsection 10. Suppose it went with amalgamation. Suppose instead of wind up it goes with amalgamation, then amalgamation can be done only and only with another section 8 having similar object. Suppose you are an education, suppose you are providing education and you are going to amalgamate with another section 8 company. So that section 8 company should also engaged in activity of education itself. Then only you can able to amalgamate with that company, or else you cannot amalgamate with that company. Subsection 11. Any default made under this section. If you are making any default in this section, then you are liable. For the company, it is from 10 lakh to 1 crore for director and every officers who are involved, with a fine of 25,000 to 25 lakhs. Suppose provided if the affairs are conducted fraudulently. In this case, every officer are in default and section 447 is applicable. let's go through some extra points for Section 8 companies. So they can call general meeting by giving a clear 14 days notice instead of, what do you think, in normal companies how many days of notice you will give? You will give 21 days, but in Section 8 companies you are allowed to give 14 days notice, clear 14 days notice instead of 21 days. Requirement of minimum number of directors or requirement of independent director. This requirement is not applicable to a Section 8 company. Even though if you does not meet the criteria of minimum number of directors, even though your turnover has crossed the limit where you have to appoint an independent director and you have still not appointed the director, then also you are not in default, because this minimum requirement condition is not applicable to Section 8 companies. Next, they need not to constitute NRC. NRC nothing but nomination remuneration committee, any shareholder relationship committee. They are not supposed, it is not supposed, if it is an optional, if they want they can constitute NRC, nomination remuneration committee, or if they want they can also constitute shareholder relationship company. It is an optional to Section 8 companies. What all the points that we have learned? A Section 8 company can give 14 days of notice instead of 21 days. The requirement of minimum number of directors and the requirement of independent director is not applicable to Section 8 companies, and it is not mandatory for Section 8 company to constitute NRC or SRC in their constitution. Hope you guys understood Section 8. So let's begin with other section. Section 9. What does this section say? It says effect of registration. Effect of registration. Suppose you have incorporated your company, but you have not received your certificate of incorporation. So in that time period from date of incorporation till you receive your certificate of incorporation, from the date of incorporation till you receive your certificate of incorporation, all the subscribers to memorandum plus other persons, nothing but the members of company, the body corporate, by its name in memorandum, can exercise all the functions of incorporated company under the Act. What does this mean? From the date of incorporation till you received your certificate of incorporation. Unless you have your certificate of incorporation, you cannot enter into any contracts. But it takes a minimum period of time for the registrar to issue certificate of incorporation. So during that period, all the subscriber to the memorandum, the persons who are the members of the company or the body corporate, whatever the name is written in the memorandum, the name of the company, the same name can be used by the company to enter into any contract. It has all the rights that an incorporated company has until you receive. So what does it mean? That from the date of incorporation you can start your commencement of your business, you can start all the operations. Body corporate, like what are the things that you can do? From the date of incorporation itself, the body corporate is considered to be having perpetual succession. So from the date of incorporation, if any members dies or any subscriber die, it doesn't mean that the company is gonna end. It has the power to acquire, hold and dispose property. It can enter into contracts. It can sue and can be sued. So from the date of incorporation, you don't have to wait for the certificate of incorporation. You can perform all those functions that a incorporated company can perform. What do you mean by property? Any property. It can be goods like movable, immovable, tangible, intangible. You have all the power that an incorporated company has. So this is section 9. So let's go with section 4. It says about the memorandum of the company. So section 2 subsection 56 says about memorandum. What does a memorandum means? Memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous Companies Act or under this act. So initially every company has its memorandum of association. It can be originally framed. It is the original memorandum, or suppose you have started your company under 1956 Act. So when the Companies Act was amended to 2013, you would have altered your memorandum of association. Even that memorandum of association is also considered as the memorandum of association, even if it is altered. Subsection 1. Let's start. The memorandum of a company shall state what are the things that are to be included in the memorandum of a company. Name of company. Name of the company. Name means what? Whether it is a limited, like public company, or it is a private limited, like private company. There should be name clause. in memorandum. Next, the state where the registered office is situated. Where the registered office is situated, that also should be stated by the memorandum. Next, so name clause, situation clause. Third one goes with objects, purpose of the company, why it is incorporated. This is nothing but object clause. Next one, liability of members of company, whether it is limited or whether it is unlimited. This is nothing but your liability. This is nothing but your liability clause. Liability clause means they can be two. It can be limited by shares. Limited by shares means that liability is limited to amount unpaid if any share is held by them. Limited by shares means only up to the amount that is unpaid if any share is held by them. Next, limited by guarantee. Limited by guarantee means the amount up to which each member undertakes to contribute. How much guarantee you are giving, you are only liable up to that guarantee, nothing but look what they contribute. Assets of the company, in the event of its wind up, they are liable for the amount guaranteed, that is at the time of wind up, to the assets of the company or to cost or charges or any expense of winding up, and for adjustment of rights of contributor among themselves. This can be explained more briefly. Themselves means between the members or within 1 year of ceasing to be a member. Or you can also make the payment of the debt and liabilities as you are contracted. Next clause is capital clause. This is only applicable to company having share capital. Share capital means amount of share capital or authorized share capital. What do you mean by this? What are the details that are to be included in the capital clause? The number of shares, fixed amount, nothing but the face value of share, number of shares taken by subscriber, and the number of shares taken shall not be less than one share. At least one member should take at least one share. Next, they should also provide the name of the subscriber who has taken the share, like number of shares, each subscriber intends to take, indicated opposite his name. Suppose there is a subscriber called Mr. H. You have written his name, Mr. H, Mr. G, Mr. M. These are the subscriber to the memorandum, and he has subscribed 5 shares, he has subscribed 10 shares, he has subscribed 12 shares. You should have to mention like this in the memorandum. All the details shall be given: the name, the number of shares they have subscribed, if there is any unpaid amount, that also you should have to mention, how much they have paid, everything you have to mention. The next and the last clause, nomination clause. This clause is only applicable to one person company. The name of other person shall be given in this nomination clause. This clause is not applicable to any company. It is only applicable to OPC, that is one person company. Now let's briefly understand what are the names that are to be selected by the company, or what are the rules they have to follow before selecting the name of the company. The subsection 2 says the name stated in the memorandum shall not be identical or resemble to nearly to the name of an existing company registered under this act or any previous company law. It means whatever the name that is mentioned in the memorandum, that should not be identical, or it should not resemble with any name of an existing company which is registered under this act or any previous company law. It should be unique name. It should not resemble, it should not looks like we have heard this name somewhere. It should not resemble with any other name, or it should not use. Here we are using not, so continue it with not itself. It should not use it is undesirable in the opinion of central government. It should not be undesirable in the opinion of central government, or suppose it constitute that any offense under any law, that it is using some wording that are constituting any offense. Suppose you are using a name which is not identical and which is not resembling with any name or that of an existing company under this act or any previous act, but it is prohibiting or it is conflicting with other law. It is conflicting with other law. Then also you cannot use it. Subsection 3. A company shall not be registered with a name which contains what? Any word or impression which is likely to give the impression that company is in any way connected with central government. You should not use any word, you should not use any impressions, any symbols which shows that you are connected with the central government, or you are connected with the state government, or you are connected with local authority, or any corporation, or any body corporate constituted by central government or state government. Next, such word or expression as prescribed. Any word or any symbol, any expression that is prescribed by the central government, you should not use that unless prior approval of central government to use such word or expression is received. If you have received the approval, then you can use. If not, you are not allowed to use. Like, what are those word or expression? Like board, commission, undertaking, like president, nation, municipal, federal, republic, central, etc. These words you are not allowed to use unless you have received the approval from the central government. If you have received the approval, then you can use these words. If you have not received the approval, you cannot use these words. If you are using this without the approval of central government, then the name is not gonna accept by the registrar. Next, subsection 4. What does the person do to register its name? Person shall give application along with prescribed fee to the registrar to reserve its name or the name to which the company proposes to change its name. So you should have to provide the application for your reservation of name to the registrar along with the prescribed fee. Or if you want to change the name of your company, suppose it's an existing company and you want to change the name of its company, then also you can fill your application form along with the fee and submit it to the registrar with the new name which you want to register. Then once you submit your application form, registrar will verify your form. Suppose if there are any defects, then within 15 days registrar will ask you to resubmit the form without any defects. It will give you an opportunity. Within 15 days you should have to resubmit the application to the registrar. Fifth one, subsection 5. Suppose after the application there are no defects, everything is clear, then registrar will reserve the name for 20 days from the date of approval. 20 days provided. Approval for reservation of name or change by an existing company. They will reserve for 60 days from the date of approval. This 60 days is for existing company. This 20 days is for new company. This is for new name. This is for existing company's name. This is clause 1, clause 2. After reservation, suppose registrar has registered your name, it has reserved your name, and after registration it is found that name was applied by furnishing. You have furnished wrong or you have furnished incorrect information. To reserve your name, you have provided wrong information or you have provided something incorrect information. Then what happened? When you do this, the company is not incorporated. Suppose before incorporating, you have given your application for the approval of name and registrar has registered your name, but in that till that process you have not received your certificate of incorporation, you have not incorporated, then in this case the reserved name shall be cancelled. Registrar can cancel your name. The person is liable for penalty which may extend to 1 lakh. This is the maximum amount, not more than 1 lakh. Suppose if it is an existing company, if it is an existing company or you have incorporated your company, then opportunity of being heard is given. First you are given the opportunity of being heard, then the registrar will direct you to change name within 3 months after passing ordinary resolution. If you are an existing company, opportunity of being heard is given. After giving this opportunity, you are directed to change your name within 3 months after passing the ordinary resolution, or striking off the name of company in ROC. They will strike off your name or make petition for winding up of company. So if you are not incorporated company, if you are a new company and you are not incorporated but you have provided wrong or incorrect information to the registrar for the reservation of name, then your name is cancelled. The reserved name is cancelled from the ROC and the person is liable for a fine up to 1 lakh. Suppose you are an existing company and you have done this default, then an opportunity of being heard is given, and then you are directed to change your name of the company within 3 months after passing an ordinary resolution, or they can strike off the name of the company from the ROC or make a petition to wind up your company. Next, subsection 6, it says about forms of memorandum. There are many forms of memorandum. This we will study later. Just remember, it is table A, table B, table C, table D and table E. Just remember the table A, B, C, D, E in schedule 1. However, we are gonna study it later, so you don't have to stress now. I'll explain it later. And subsection 7, that any provision in memorandum or article, any provision in the memorandum or article for a company limited by guarantee not having share capital. Any provision that is mentioned in the memorandum or it is mentioned in the article for a company which is guaranteed but it does not have any share capital, then this person, they have the right to participate in divisible profit otherwise than for members. It is void. So that's all about this section 4. I hope you understood this, and if you have any doubt, please comment and let me know if I want to make any changes to these sections or you want to continue in the same manner. I hope you understand, and in the next section we are going to start with section 5. It's article of association. So please do subscribe and motivate me. Thank you.